Hello, this is Matt on the Moon Family Sedan channel. Anybody out there curious as to what the asshats at the SEC are doing right now? Well, look at this headline from the Crypto Basic. SEC files motion to exclude testimonies of 10 Ripple experts. That's right, folks. The SEC wants to shut up 10 of Ripple's expert witnesses. I'm willing to hazard a guess here as to why. Are you? I'm guessing, I'm just going to do a little supposing here, that perhaps it has a wee bit to do with the fact that they have very persuasive arguments that they do not want the judge to see, or a jury should it get to that point. I'm going to go ahead and hazard that guess, yes. So I'll share with you what's been said, as well as information from this story, also from the Crypto Basic. Ripple wants court to exclude one of SEC expert testimony. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I'm not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos all up in this bitch about crypto-related topics, but just as a hobby, and just for fun, damn it. And if you don't like it, well, you can just get out. So into this first piece, again, 10 of Ripple's expert witnesses, they just shouldn't get to say anything in this case, the SEC says. Piece reads as follows. The SEC has filed an omnibus motion to exclude the testimonies of 10 Ripple experts in the ongoing lawsuit. The Securities and Exchange Commission noted that the experts' opinions should be excluded because they have nothing to do with the three prongs of the Howey test. Okay, pause right there. That is rich. Now, first of all, I don't think that the judge on the whole is just going to go along with this. That would be unreal to me. But it is super rich for them to be arguing, hey, this doesn't have anything to do with the prongs of the Howey test. Because if you may recall, the SEC, and this is one of the most ridiculous things that came to mind upon reading that, the SEC does not claim what the common enterprise is as it pertains to Ripple and XRP and the Howey test. Now, initially in the case, they stated that Ripple was the common enterprise. Then they backpedaled. Nope, that's not it. And now they do not claim what the common enterprise is. Though they do say things about common interests from various parties within the XRP ecosystem. But if you look at what they're arguing, and this is so damn absurd, although they don't flatly state what they're claiming the common enterprise is, they do argue that basically, and I'm paraphrasing here, but the totality of the entire XRP ecosystem is the common enterprise. Can you imagine that logic being applied to anything else? Like, just think about gold. Can you imagine applying that to gold? So gold miners are in a common enterprise with the entire gold ecosystem, including manufacturers of electronic devices that use gold in the manufacturing process, and also fashion firms, jewelry companies selling gold jewelry. That's a common, no, it's a common interest, you freaking asshat pricks. Absolutely not. It's completely absurd. And so for them to come out here and say, this doesn't have anything to do with the hangs of the Howey test. Well, you little asshat pricks, you are not even naming what a common enterprise is. That's kind of an important prong in the Howey test. Don't you think? Duh. So here's a quote, though. Defendants and their experts ignore Howey and controlling precedent and instead ask the court to decide the question of whether defendants offered and sold XRP as part of investment contracts by looking to other legal regimes or to facts that courts have repeatedly held are irrelevant to the Howey analysis. End quote. That's what the SEC said. Piece continues. Some of Ripple's experts the SEC wants to include their testimonies include Professor Alan Schwartz, Peter Adrians, Alan Farrell, and Carol Osler. The SEC asked the court to exclude the testimony of Professor Schwartz for purportedly reviewing some of the contracts through which Ripple offered and sold XRP to determine whether the written contracts meet the Howey test. And here's a quote from the SEC. Schwartz's opinions should be excluded because contract interpretation is an inappropriate subject for expert testimony, end quote. Now look, I'm not saying that I buy that argument from the SEC that this is inappropriate for Schwartz to be talking about here. But even if that's the case, you throw out everything that he says because of that? Wouldn't you just say this portion is not something that's suitable or relevant or so on and so forth? But of course, the asshat pricks at the SEC, they do what they normally do, and they overreach. And sometimes it comes back to bite them on the rear side and I sure as hell hope it does in this particular situation as well. But they're being completely disingenuous. 10 of them should just be gone? Really? Peace continues. Furthermore, the SEC also requested that the court exclude the testimonies of Adrians, Farrell, and Osler, who stated in their reports that XRP has other uses other than investment purposes. So pause again. Think about this. I don't think that statement alone should mean that that even that portion gets thrown out. But that you throw out everything that they say specifically because of that one thing. Is this rational? Well, of course not. Peace continues. Per the SEC, the existence of use does not advance the Howey inquiry because different courts have continually held that items that have actual use can still be sold as an investment contract. And the SEC asshat said, quote, the relevant inquiry is not whether something has used, but whether, I think they meant to write was used, considering the entirety of the economic inducements and realities, an investment contract was sold primarily for use or sold for its potential for profit, end quote. Okay, but here's the thing, you little asshats, is when it comes to XRP specifically, as it pertains to this case, well, utility does actually matter. And if you're talking about utility, and especially if it's within the context of it being separate from what would constitute otherwise constitute like a scheme or a potential investment contract, if you're looking at utility and people using it, many having no idea that Ripple even exists when they jump in and purchase XRP for the first time, isn't that relevant? The SEC wants that out too. Because reasons, folks. Because reasons. These people are just awful monsters. They're disingenuous liars, and I got no goddamn time for that, frankly. Now, here's a headline from the Crypto Basic. Ripple wants court to exclude one of SEC expert testimony. Prominent blockchain company Ripple has filed a redacted motion to exclude the testimony and accompanying exhibits of SEC expert 2 from the public docket. While the lawsuit centers on whether Ripple's XRP sales constituted an investment contract, the defendant said the expert denied having any opinion on whether Ripple offered unregistered security. Ripple noted that instead of giving an opinion on whether its XRP sales constituted security, SEC Expert 2's testimony offered a tutorial to the jury on the registration and disclosure of security offerings under the SEC Act of 1934. The leading blockchain company said the testimony is entirely irrelevant to the main issues the SEC must prove in the lawsuit. And Ripple said, quote, his testimony has no bearing on the questions before the court. It would merely confuse and distract the jury, inviting them to reach a verdict on the improper basis of whether defendants' XRP distributions should be considered investment contracts as a matter of policy, rather than whether they were investment contracts as a matter of fact and law, end quote. I'll tell you what, that sounds a hell of a lot more reasonable than that crap the SEC was saying. Peace continues. SEC Expert 2 also impermissibly assumes that XRP was an investment contract by opining that Ripple deprived investors of key material disclosures. So I'll just say here, and I've talked about this particular expert on the SEC side, who is asserting that to have understood why XRP holders purchased the XRP that they purchased. Well, when put on the spot, acknowledge that because mind you, there are thousands of affidavits from John Deaton, don't forget that. Thousands of affidavits from XRP holders, sworn statements of XRP holders stating why they purchased XRP, and many stating that they didn't even know Ripple, the company, existed here. As it turns out, this expert didn't even ask a single XRP holder why they purchased it, but made all of these broad assertions. Doesn't that sound more so like something that should be thrown out than the crap that the SEC was asserting? Well, I sure as hell think so. Peace continues. The blockchain company requested that the testimony of SEC Expert 2 needs to be excluded for several reasons. According to Ripple, the expert needs to gain experience with digital assets. Ain't that the truth? Furthermore, the expert air quotes, right? Furthermore, the expert did not analyze the mix of information available to XRP purchasers, which Ripple sees as the starting point for a materiality analysis under the Second Circuit and Supreme Court law. It said, quote, as such, SEC Expert 2 opinions are nothing more than a series of ungrounded assertions and are therefore inadmissible. The court should exclude his testimony in its entirety, end quote. So there you go. It's just a mix of information, as they stated here in the article, available to XRP purchasers. Did not analyze, and so it's amazing to me that the SEC, like, they did fumble on this one, honestly, to hire an expert witness like this, and then for something like this to happen. Yeah, you drafted the wrong guy. Let's just be clear there. This did not go well for the SEC. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.